All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. Could you speak up just a little?
I do.
Wonderful, thank you. I want to make sure our court reporter can hear you.
Yes, ma'am.
If you'll just tell me your name, please.
Shaquille Blunt.
Thank you, Mr. Blunt. You are here in case 25 CF 2210 on 2 counts of failing to register violations. Each of those is a third-degree felony with a maximum penalty of 5 years in prison. Have you had a chance to talk to your lawyer about those original charges and any possible defenses?
Yes, ma'am.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am, I have.
Did you read and sign the agreement?
Yes, ma'am, I did.
Is that your signature on the last page?
Yes, ma'am, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to go to trial?
Yes, ma'am.
You're giving up other constitutional rights as well. I'm going to go over a few of those with you. Do you understand you're giving up your right to plead not guilty and have a trial by jury?
Yes, ma'am.
Do you understand you're giving up your right to remain silent and not incriminate yourself?
Yes, ma'am.
Now I need you to speak up.
Yes, ma'am. Yes,
Okay,
ma'am.
great. I just want to make sure the court reporter can hear. Do you understand you're giving up your right to have the state prove that you are guilty beyond a reasonable doubt?
Yes, ma'am.
Do you understand you're giving up your right to confront witnesses against you and cross-examine those witnesses?
Yes, ma'am.
Do you understand you're giving up your right to defend yourself by calling witnesses and presenting evidence?
Yes, ma'am.
Do you understand you're giving up your right to appeal your conviction and sentence to a higher court?
Yes, ma'am.
Knowing that you're giving up all of those constitutional rights, do you still wish to proceed with the plea?
Yes, ma'am.
All right. Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am, he did.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet. It shows 94.2 total sentence points. Any objections?
No, Judge.
All right, and to the state, this appears to be a downward departure.
Yes, ma'am, it is a negotiated enforced plea. And we also need to announce, ma'am, that there's an all pause on count 1.
Okay, thank you. Is there any exculpatory DNA?
There is not.
Okay. I do find a sufficient factual basis based on my review of the arrest report. Mr. Blunt, if you're not a U.S. citizen, do you understand you could be deported?
Yes, ma'am.
All right. Looks like you are only pleading to count 2. How do you plead to that count?
No contest.
I accept your plea. I find it was freely and voluntarily entered on count 2. In accordance with your agreement, there's an adjudication of guilt on count 2. You will be placed on community control for a period of 2 years with standard conditions of community control, including a GPS monitor that'll be attached at $1 per day. And there is a 5-year suspended prison sentence. It's conditioned upon your successful completion of that community control. So meaning if you, let me just make sure that I get it right and I've got it on the record. So if Mr. Blunt completes successfully his community control of 2 years with no violations, then the suspended sentence would not be imposed, correct?
Exactly, ma'am, that's the intent.
That is correct, ma'am.
All right. Mr. Blunt, do you understand that?
Yes, ma'am, I do.
Is that your agreement as well?
Yes, ma'am.
Okay. So do you understand that if you have a violation of your community control, you're going to be facing 5 years in prison?
Yes, ma'am.
All right. The court is also imposing court costs in the amount of $867.
I'm sorry to interrupt, but since count 1 was null pros, the court costs are just $515. They're different statutes.
Ah.
That count 2 statute isn't on our list for that.
Thank you. So the court cost, I take it back, it's not 867, that was tied to count one. Madam Clerk has advised me it's 515 in court costs. So there's also a monthly cost of supervision associated with your community control, and I believe that's $40 a month, but probation can correct me if I'm wrong, and then there's a surcharge.
Yes.
Okay. Thank you. All right, so, and to probation, where does he go to get the monitor? Can y'all do that if,
They'll
okay,
come directly to us after this.
wonderful, thank you. Did I cover everything, Mr. Heath?
Two things, Judge. If the court approves, there's a $1 fee for the court, for the GPS, if
Yes.
that's applicable.
Yes.
The second thing, Judge, is that Mr. Blunt is on GPS monitoring from Georgia, but under Florida's law regarding sex offender, from a long ago sex offender issue. So it's going to be tandem, and there should be no need, I don't know how probation addresses this, there should be no need for two monitors. Is that something that he can work out with you guys, or I just want to make sure the record's clear that he's not subject to both GPS monitors?
I haven't had that issue come up before, so,
Can you repeat that? He has GPS with us and then what would be the
He has GPS with you pursuant to Georgia.
It would be one.
Understood.
Yeah.
okay. So he's already got a monitor? Okay, so, and I have no idea what the Georgia situation is, but the monitor would need to remain on throughout the entire 2 years of community control in this particular case.
Understood,
At the
Judge.
cost of, well, what is the cost of it now that you're paying?
What do you pay now for GPS? Do you know?
It left my brain so much. I don't try to keep up with the figure. I don't know. It was over 3,000. I don't know how much per day. I don't know.
Whatever the standard is, he's on the standard.
Okay.
And we're just trying to avoid that with the $1 in this. If he's already on standard on that other case, that jurisdiction lies there, I'd assume. This case, as long as it's recorded accordingly to this pursuant to this plea agreement, I should be fine for probation.
Okay, so I just want to make sure this order in this case is not going to modify whatever order from Georgia or wherever with the GPS, whatever cost was ordered in that case this order won't affect that.
Understood.
So let me make sure I understand. Is this an additional $1 per day for this case? Or since he's already got a monitor in another case that he's paying for, is there no cost or what?
As far as the state's concerned, ma'am, I wouldn't think we necessarily need to have the additional $1 a day, but if that one were to go away, the monitor does need to remain on him, so then I think the dollar would kick in at that point if we became the only monitor.
Okay, let me ask probation. So I guess do y'all know whether he is paying for a monitor or being charged for a monitor?
Yes,
He-
we do charge $4.50.
$4.50 a day? And that's from an order from another court?
Yes, for Georgia, his case with Georgia, so that can stay the same.
Okay, so I'll take off or I can put on here about the $1 a day. If the monitor gets removed or expires from Georgia or whatever, it has to stay on for this case, and then it would go down to $1 a day. I have no idea how long that order from Georgia is for the monitor.
We do, Judge, and it's going to go beyond this case.
Oh, okay.
So it's covered. I'm attempting just to make sure the record's clear as to how this court is addressing this plea with regard to the other will be worked out. I can say that.
Okay, so what do I do about this? I mean, it says on here $1 per day, but if he's already paying for it for some other case, then he's not going to have to pay an extra $1.
Understood, Your Honor. Respectfully,
If the court's comfortable with that, then the court could waive that $1 a day, since
Okay.
it's already paying for it.
Okay.
Leave that up to the court.
Yeah, the court is not going to impose an additional cost for a monitor he's already paying for, so,
I think that language would work, Judge. Thank you.
okay.
Thank you.
Sure, I'm going to write on here. I'm writing no additional cost for this case for the
Understood.
monitor.
That's in her order. So what is her order?
All right, did I cover everything?
Yes, Judge, from defense side.
All right.
Yes, ma'am.
All right, so sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. You're
Thank
probably
you.
going to have fingerprints, and then you need to see Officer Hernandez, who's sitting on the front row. She's with probation,
Yes,
and then
ma'am.
when you leave the courthouse, go straight to their office and check in immediately.
Yes,
Okay?
ma'am.
Good luck, sir. Thank
All
you.
right. All right.
Your Honor, that's all I have before the court this morning. May be excused.
Yes,
Thank you, Judge.
Your Honor?
Yes.
Mr. Keith, I have James Casey. For Mr.
Oh, that is, that hearing is actually for July, and it's a bondsman issue. It doesn't involve the defendant or the attorney.
Okay.
If there's, I did an order setting hearing, it's actually July 16th, and I think it got put in as June 16th. So,
Okay, thank you, Your Honor.
sure. Mr. Rare? Mr. Shaw? All right, Mr. Nopes, come on up.
Your Honor, I've got Pamela Henson.
Okay. Ms. Pamela Henson, 23 CF 818 and 25 CF 2466. All right, and Ms. Henson is present.
Judge, I think we're just basically here for a status.
Yes. Status on how the competency restoration is going, and I saw that the forensic mental health specialist filed a report yesterday, which I reviewed. And does the state wish to be heard, or?
Mayor, I also read the report. Sounds like things are moving along.
And Mr. Nopes, anything you wish to be heard on?
Judge, it just basically says she's fully compliant at this time with her conditional release plan. I will tell the court that we do have the deposition of Chad Chumbley set for July 1st at 1 o'clock via Zoom.
I have a question about that.
We've got, and we have gotten him served. That's the main witness. And so we are making progress on defending the case.
Great. All right, so we need to set another status hearing. And we have July 21st, or what would you like?
Sorry, I guess.
Judge, I could make July 21st work.
Okay.
It's fine with the state.
All right, how about July 21st at 9 o'clock? And it'll be another competency status. See how we're coming along.
Okay, a couple questions for you.
Thank you, Ms. Henson. You're making progress. We appreciate that very much. So, yes.
I'm gonna come back here and talk to you, okay?
Okay.
Judge Clark? Now, speaking of restoration status, would the court entertain taking Mr. Kyle Bowman back in?
Yes, we'll go ahead and take that case.
Steve Medina with Caleb, it's Caleb Bowman.
I'm sorry,
Yes,
I was-
it's okay. Caleb with a K Bowman, Your Honor,
Okay,
is approaching. He's here with his grandmother today. His case is 25 CF 2197. I'm sorry, I can't recall the exact particulars, but I had received a contact within the last week or 10 days or so from the forensic officer saying that he's doing well on his restoration. I don't think he's far from restoration, according to her. He is going to set a meeting with me in the near future so we can go over things, and I would ask to set him out I think it's best that he not be on the pretrial calendar if possible until we get things worked out as far as competency. Can we put him on a miscellaneous date for a status conference in maybe 60 days, something like that?
The state would agree with that, ma'am. Mr. Bowman has been participating according to the report and doing well, so we commend him for that. And we would go ahead, we would agree to set him for a status, and then at that point, we would see whether or not he'll return to the pre-trial docket, give Mr. Medina a chance to meet with him.
All right, I did review the report from the forensic mental health specialist. It's dated June 11th, and it detailed some progress that Mr. Bowman is making. It was a favorable report in that regard. So are we looking at July or August?
Mr. Medina, I believe you said you want to meet with him first. What would work?
I think it'd be better to August, and then it could serve as the pretrial conference, and hopefully it'd be the last time that he won't be on a regular docket
Okay,
if he's determined competent.
The state has no objection to that, ma'am.
all right, so we've got August 18th
That's fine, Your Honor.
at 9 o'clock. I'll put it down as competency status and pretrial conference.
Thank you, Your Honor.
Thank you.
Okay, you're free to go.
Thank you, Your Honor.
Thank you.
Thank you. Set an appointment, okay? Thank you very much. Have a nice day. Thank you, Your Honor.
Thank you. All right, I see Mr. Ballack. Come on up. And this would be Mr. Robert Dunaway. Okay.
I still need another minute.
Oh, you
to
need
speak
another,
with his
wait, just,
family.
yeah. Okay,
Just 1 minute, yeah.
okay. So, Mr. Harper, you ready to take your cases? Okay. I think you might, you have one and then you're about to have another.
I have David Bishop, number 7 on the docket, Judge.
I think he
refused transport
refused.
this morning. I was retained, or I was appointed on that particular case last week, and I'm still in the process of getting discovery. I've spoken with the state, and I understand that the offer is probably going to be guidelines, but I would ask to move it to the next miscellaneous so that I can meet with him.
All right, and I think this is case number, is it 24 CF 277?
Yes, Your Honor, and I would enter a denial at this time.
Okay. And that's David Bishop Sr. I did receive word he refused transport. So we will set the case on July 21st at 9 o'clock. And then you're about to get appointed on another case, so bear with me. This is Ted Felder, 22, CF 756. I believe he is an inmate.
I think, and if Madam Clerk could dig a little bit, Ted Felder's, his name sounds familiar to me. I think we might have withdrawn off of his
check.
new law cases,
Let me check.
or there was some sort of change of disposition on, either he retained private counsel or something, I don't remember.
So here's the situation. This is a violation of probation. arraignment. And I was looking at the case last night. I saw that the Office of the Public Defender was appointed, and they filed a motion to withdraw on May 18th because of a conflict, but I couldn't find an order granting their motion to withdraw. So I figured I needed to address it today, but my paperwork is showing you're unrepresented by an attorney in this case. This is 22 CF 756, violation of probation case. So I have Mr. Harper here. He's an attorney with Regional Conflict Counsel. So when the Public Defender's Office withdraws, the next attorney I appoint is Regional Conflict Counsel. Have you retained a lawyer on this particular case?
Yes, ma'am. I was expecting to see Ricky Durham in court today.
Okay, so did you
told me
retain
that
him
he'll be
on
here.
another case? A different case?
No, I retained him for everything, my VOP and my misdemeanor case. So I don't know what the problem is. I talked to him on Friday, and he said he'd be here Monday morning. He said he...
Okay, hold on just a second, and let me take a look, okay? Because I do see that there are 2 misdemeanor cases.
Yes, ma'am.
That are new. Then there's also a new felony case, 26 CF 1039,
Yes, ma'am.
but I didn't see, let me check that new one. I looked at it last night, I didn't see an attorney in there.
Your Honor, just from the state's perspective, I have had some communication with Mr. Dyer, not specifically with respect to this DOP, however.
Okay, so he has not filed anything in the new case, 26 CF 1039, but Mr. Ferris, if you have had communication with him about the new case, or?
I've received a communication from him, honestly, without any reference to a particular case, and just from May 13th is when I had communication.
Oh, well, the date of arrest in the new case, 26 CF 1039, is after that. So, let me just look at one other thing.
Yeah, you probably need to talk to Ricky. Okay, so today I'm going to enter denial. All right?
So
Sorry, no, that's, I apologize. I do have more recent communication with him with respect to the DOP from May 20th.
Oh, with this VOP, 22 CF 756?
Again, there's no case number in the email, but,
Okay.
20th email concerning DOP.
Okay.
So,
He hasn't filed anything in the case?
Did you see 26 of 1039?
Yes.
Okay.
Did you
Your Honor,
see-
can we pass Mr. Felder's case? I'll text Mr. Dayron and see if he's got any input that he wants me to address this morning for the court on Mr. Felder's case.
Okay, let me just confirm.
That number is,
Did you see an attorney in
you got
the
it.
26?
Yeah, I don't know.
I didn't see
I talked to him. He was like, he gonna see me today.
I didn't see an attorney on it.
Okay. So, Mr. Felder, we don't see that Mr. Dyram has filed any paperwork stating he's your attorney in the case you're here on right now, which is 22 CF 756, or in the new case, 26 CF 1039. That case is not set for today. That case is set for an arraignment in July.
So, ma'am,
Yes.
he hasn't said nothing for me, like my lawyer, period?
I don't know about your misdemeanor
On this
cases.
case. This judge is just talking about this case.
He is on your misdemeanor, apparently.
That's right. Yeah.
Do you want me to pass the case?
back out.
Your Honor,
or-
if I can just pass on it to see if I can get a response from Mr. Dayram.
Okay, we'll recall you in a few minutes, okay?
Okay, thank you very much.
Thank you.
Thank you, Judge.
Sure. Mr. Ballack, are you ready?
Just finish the terms of the.
Oh, okay. All right. Mr. Gates or Mr. Koch, do you have a case you'd like to call?
I believe we are ready. Are we ready for recess? Sure. Excellent. Judge, we do have a hearing scheduled, Nicholas Carasso.
Okay.
We are ready for that.
Okay, well, we'll proceed with that then. All right, this is case number 22, CF 360, Nicholas Carasso Jr. We're here for an evidentiary hearing on violation of probation.
That is correct.
All right.
Your Honor, my client is in a wheelchair. Is it okay if he's
Yes.
right here, if I stay at the table? Thank
Of
you.
course.
And Mr. Carasso is present to my left, Your Honor.
All right, yes, he is present. And is the state ready to proceed?
It is ready now.
All right,
Can I just refocus, Your Honor?
sure. All right.
Thank you, Judge. We are ready. Thank you.
All right, so, Mr. Carasso, are you, Mr. Koch, you might want to move that box. I don't know if he can see. Thank you. All right. Good morning, sir.
Good morning, ma'am.
All right, so we're ready to proceed with a contested hearing on the allegations that you violated your probation, sir. All right. Call your first witness. All right.
Hey, Your Honor, I did scan them into the minute sheets and she found them. She's just going to put them in. Thank you.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you, ma'am. Just have a seat. And once you get situated, if you will say and spell your name right into the microphone for the court reporter. You might want to say that one more time. I think I had the volume turned down, and I don't think the clerk heard. I'm
Zita
sorry.
Veres. First name is Zita, last name Veress.
Thank you.
Good morning, Ms. Ferez.
Good morning.
By whom are you employed, ma'am?
I'm employed by the Florida Department of Corrections.
How long have you been with them?
I've started in May of 2019.
Can you tell us a little bit about what your duties are with them?
At this time, I am a corrections probation specialist. I supervise high-risk offenders.
And in your position as a supervisor of high-risk offenders, did you have an opportunity to supervise Mr. Nicholas Carasso?
Yes, ma'am.
Do you see that individual that you refer to as Mr. Carasso in the courtroom today?
Yes, I do.
Could you point him out for us, please?
He's right there.
Okay,
In a
just
wheelchair.
kind of describe a little bit, so either what he's wearing or...
He is in a dark green jumpsuit, I guess, in a wheelchair.
Ma'am, we'd ask the record to reflect identification of Mr. Carasso, the defendant in this case.
The record will so reflect.
And Ms. Ferez, tell me a little bit about how you came to supervise Mr. Carasso. When did you begin the supervision with him?
I started supervising him on February 21st when I transferred him to Pensacola to the REAP program, which he did not last. He did not stay more than 24 hours. So he returned to Okaloosa County on the same day, and the actual supervision started with me in the afternoon of February 21st of 2025.
And when you began your supervision with him, did you have an opportunity to go over the rules, regulations, the expectations of probation with him?
Yes, I have. On the next day, on the 22nd, I went over with all of his standard conditions, all sex offender conditions, and his modification. And then on April 22nd, I have re-instructed him on all of his conditions as well.
And do you feel like he understood those conditions?
Yes, definitely he did.
And has he been in compliance with those conditions?
He has until he violated this recently.
And tell me a little bit about that. When was the violation?
I'm sorry. It was January 20th of 2025. I did a warrantless planned search on his residence, which was at 1 Miracle Strip Parkway, Fort Walton Beach, Economy Motel, room 124. I went there with Officer Profit. We went through the whole room. This is usually planned biannually on every sex offender with his designation. We found 2 internet-capable devices. One of them had a lock on it that I could not get into. The other smartphone, the tablet, had a lock on it. I couldn't access it. And the smartphone opened right up, and it opened to an internet access.
And I just want to go back. You indicated that it was the 20th of January of 2025. Was that 2026?
It was 2026, I'm sorry.
Okay, I just wanted to be
Yes.
sure. So what is the significance of what you found with the smartphones?
He's not allowed to have internet-capable, he's allowed to have internet-capable devices. He's not allowed to access internet or any kind of internet access of any kind. The smartphone immediately logged into an internet browser. So that had internet. When I asked him why he did that, he stated that his flip phone was very annoying and he needed it to access his games and pay bills and access internet. So he admitted using internet immediately.
And did that then constitute a violation of his probation?
Yes, ma'am.
And would you say that was a willful violation?
Yes.
Were there any further violations at that time?
Not at that time, no.
Has there been since then?
But he has been arrested on the warrant, and he's been incarcerated, so he has not violated since then. Prior to that, he has, though.
What were the nature?
Failed to register, and that was back in January 4th of 2024.
Okay. Nothing further for you, ma'am, at this time? Thank you, Judge Clark.
Thank you.
Cross?
Yes, Your Honor. Good morning, Ms. Perez.
Good morning.
Okay. I first want to talk about that 222, back in 2025, you went over all those conditions with my client.
Yes,
Was he provided a written copy of all those conditions?
yes.
Okay. Is this, not standard, but is this where he initials by everything? Is that how you guys kind of go over the conditions?
Actually, his original conditions were actually went over with him with the previous officer on the day when he started probation. I recap everything with all of my offenders when I first get them or first meet them, just so they understand of all their conditions.
Yes, okay.
And then, of course, he was modified at that time, so I also had to recap the modification with him.
Yes, thank you for clarifying. Now, on the day in question, that January 20th, 2026, inside that hotel room, what hotel was that again? Or
It was the
motel?
Economy Motel,
Okay, thank you.
room 124.
Was that room rented under Mr. Cross's name?
Yes, it was, as far as I know. Yes.
Okay.
He stayed there with his ex-wife sometimes. His ex-wife lives in Washington County, I believe, and she would come and visit. I'm not sure if her name was also on that room or not.
Okay. And then inside that room, you stated there's 2 devices, a smartphone and a tablet.
That is correct.
Okay. Now, the tablet was locked.
Yes.
Were you able to access into the tablet?
No, I could not get into it, and when I asked him for the code, he could not remember the code.
Okay.
But he did state that that is the device he uses to play games on.
Okay. Now, just focusing on that tablet, because you weren't able to get into the tablet, is it true you weren't able to confirm that that was an internet-capable device, just a tablet?
I did not get into it, no.
Okay. Now, focusing on that smartphone, like you said, there wasn't a lock on that. You were able to get into the actual smartphone.
Correct. As soon as I powered it up, it connected to a web browser.
And there were no other devices in that hotel room?
No, only those 2 that we found with Officer Prophet.
Okay. Because you supervise high concern or special kind of probationers, is there, in his situation, is there classes or treatment that he can take and then one day be eligible for the internet?
That is correct.
Okay.
He is supposed to complete a sex offender treatment, which he actually did on 9/4/2024. But then he was supposed to complete a risk assessment, which he never did. At that time, the risk assessment usually allows them or recommends internet usage or not. They just have to complete it.
Okay. And so that process, usually you complete the sex offender treatment, then you go through that risk management, and then potentially, of course, you got to get signed off by the judge and everybody. That's the process of maybe one day being able to use that internet.
That is correct.
Okay. Your Honor, I have no further questions. Thank
All
you.
right. Ms. Basso, anything further?
No follow-up, ma'am, thank you.
All right. May the witness be released, or should she be, is she subject to recall?
I'll just ask you subject to recall, just in case.
All right. Thank you, ma'am. You can return to your seat.
And ma'am, the state has no further witnesses or evidence at this time.
All right. Defense?
Judge, may I have a brief moment?
Sure. Okay.
Thank you, Judge. At this time, if I may call my client, Mr. Carasso, to the stand.
All right. Do you want him to testify there or come up
I
here?
think that's, yes, if he can testify right here, that's fine. State.
Is that okay with you?
Yes, ma'am, I understand the situation.
Okay, so if we could get the microphone close to him so we can make sure that the court reporter can hear him.
Excellent.
Mr. Carasso, I'm going to swear you in, so I need you to raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. If you could please state your name. Okay, I think we need to get the microphone a little closer to him. Actually, let me turn, I had the microphone turned off because I knew you were having a private conversation. Let's try that one more time.
Nicholas Carrasco Jr.
Now we're good. Thank you.
Thank you, Judge.
All right, go ahead, Mr. Koch.
Okay, Mr. Grasso, I first want to talk about back in February, around 2021, 2022, you heard direct testimony. Were you instructed on all the conditions of your probation?
As I asked for them, I was only given certain amount of information, not the complete information. I found that out later when an officer came to check on me, and then he told me some of the, and they never told me that. What's that? And then he told me the rest of my rules. I go, and I thanked him for it. That was it. When he came and checked on me at the hotel.
Now, the alleged incident was January 20th, 2026. At that time, were you aware you weren't allowed to have any internet-capable devices?
Not access to any internet devices.
So let's talk about that a smartphone was allegedly recovered in that hotel room. Whose smartphone was it?
It was mine.
Did it have internet-capable devices?
Yeah, but I didn't have them. I wasn't. All I had when I got the phone was text and talk. It's a card you get at Walmart that says text and talk only.
So your testimony today, you never used that phone for internet?
Right. I only used it when the information popped up, and I called my sister in California, says they're saying to check for a bill, but I don't, so she would access and make the payment on my bills.
Now, on direct testimony of your probation officer, it was alleged that you told her that you got tired of using a flip phone, and you needed to pay your bills online.
No,
Accurate?
no. I told her that the first phone, I kept paying on it, and they wouldn't accept the payment. So I got a second phone, and it wouldn't, when someone called and left an answer on the answer machine part of the phone, it wouldn't let me access that. So I went to get a phone I told them I don't want a smartphone, I wanted just a phone that's similar to the flip phone, but just to do text and talk, because I'm only allowed to have text and talk. So they introduced me to the phone I had, and I went, the first month went with the card, then I went to, at the end of that month, I went to AT&T and told them I can only have text and talk on this phone, and it was $30 a month.
Now, at that time, January 20th, 2026, at that time you completed that sex offender treatment?
Yes, and I got a certificate saying that I completed. Then I asked, is there anything else I need to do? And she said, no.
Who did you ask?
The lady I was talking to that I went through the sex offender treatment with.
She informed you your treatment was complete?
Yeah, she told me it was complete. There was nothing more that I had to do. And I asked her also, do I have to pay anything else? And she said, no. I made all the necessary payments, and I finished the class, and she sent me a copy of the paperwork she sent to my PO.
So you're unaware of that risk assessment that you needed to follow?
Yeah, she never mentioned that. They only mention what you asked, the question. They don't tell you, well, you also need to do this. Unless you ask, we're in the dark. I have no idea what I'm supposed to do unless you tell me what I'm supposed to do.
No further questions, Your Honor.
All right.
Mr. Carasso?
Yes.
You told us that an officer came over and was checking your phone, and you referred to a he. Who was that?
He,
Yeah, you said the officer came by your hotel.
oh, yeah, he came to check on me. And he says that he was just there to follow through with if I'm doing what I'm supposed to do on my probation. I says, but I don't know all the rules. I told him I don't know all the rules of the probation. They only tell me whatever I question, what do I have to do now? Then they tell me. If they don't tell me, well, you're also going to need to do
Sir,
this.
I asked you who the officer was. That was the question.
A guy.
Who was the officer?
A man,
A man. Okay. Can you be a little more specific, sir? There's several probation officers.
no, it wasn't probation, it was an officer. Wasn't a
Officer,
prob,
law enforcement officer.
Yes,
So it
sir.
wasn't even a probation officer.
No, it was
It
a
wasn't
law,
someone that was responsible for supervising you and sharing rules.
no. Yeah, he had the
That was
paper,
my
yes,
question.
he had the paper, tell me what to do.
That was my question. Okay, and you said that you were using your phone and you kept paying your bills with it, but it wasn't working right.
Right.
So you were
No.
using your phone to pay your bills, correct?
I was using the phone to, which phone are you talking about?
Well, you just told us a moment ago, you kept using the phone to pay your bills, but it wasn't working right, so you got.
No. I had this, no, I said the flip phone wasn't working right. So I had to I went from one flip phone to another flip phone to the other phone that I said I did not want only text and talk on. But when the bill showed up, I called my sister and says, bill showed up on my phone on the text, on the part that does the text and talk. Can you pay the bill? Because I don't know, I can't pay the bill, I'm not supposed to. And she said, okay, and she went on to whatever it was
And took care of your bill.
and took care of my bill.
But your phone, when it was turned on, it connects immediately to the internet, doesn't it?
Not that, no, not that I know of. Not that I know of.
I have nothing further, sir, thank you.
Redirect?
None, Your Honor.
All right. Any further witnesses?
Nothing from the bench, Your Honor.
All right. Thank you.
Your Honor, we ask to recall Ms. Morales, please.
Okay.
Clarify something.
I got this. This is not important.
All right, and ma'am, you're still under oath.
Ms. Ferris, I just wanted to clarify something. When you indicated that you routinely instruct offenders when you begin their supervision, didn't you?
That is correct.
And in this case, you indicated that you did that with Mr. Carasso.
Yes, I did.
And did you go over all the conditions with him?
Yes, I did.
And specifically, did you go over the fact that prior to being on any internet-capable device or using the internet, he would have to accomplish a risk assessment?
Yes, I did. This was section 30 of his conditions.
She said I just have to.
And did he ever complete that risk assessment?
No, he has never did.
So just to be clear, without that risk assessment or any type of safety plan, he would be in violation if he accessed the internet
That is correct.
or had any device that was capable thereof.
Yes,
And when you searched his room that day, you indicated that you had found a smartphone
yes,
and that he admitted that was his.
yes,
And when you powered it up, it did immediately connect to the internet.
that is correct.
And did he also, I think you admitted that he was using, he said that he admitted he was using it.
Yes.
I have nothing further. Thank you, ma'am.
Cross?
Nothing from the bench, Your Honor.
Thank you, ma'am. You can return to your seat.
The state has nothing further, ma'am.
Okay.
Just argument on the closed session.
All right. All right. Go ahead whenever you're ready.
Ma'am, do you prefer here or?
Wherever you're comfortable is fine.
Ma'am, Mr. Carasso is before the court on a violation of probation, specifically that he was accessing the internet and using devices that were capable of accessing the internet. The court has heard credible evidence, we believe, from his probation officer, Ms. Perez, that he was in fact instructed on all the conditions that would apply to him as a sex offender while on probation, and also that he was actually re-instructed on those. Specifically, he was also instructed not to have any devices that are capable of access to the internet. So based on her testimony, we believe that was very clear, and that there was no reason to believe that Mr. Carasso was unfamiliar with that term and condition, or that he failed to understand that term and condition. The court also heard evidence that he searched his room, that there were in fact internet-capable devices there, that when the device was powered up, the smartphone, it connected directly to the internet. That would constitute access to the internet, and that would be in direct violation of the term and condition of his probation. Additionally, Mr. Carasso also admitted to using the smartphone to access the internet to Ms. Perez on that day. The court heard that from her testimony. So we do believe that, based on the testimony and the fact that he was instructed on the conditions, that this was a willful and substantial violation given the nature of the underlying charges, and we would ask the court to find that he violated his probation.
Thank you. All right. Mr. Koch?
Yes, Your Honor. Yes, Your Honor, we are here for violation of probation. The term devices, but from the testimony of the probation officer, I just narrow it to that smartphone, because from testimony, they weren't able to access that tablet and to confirm if that was capable. So, but we still have a smartphone out there with direct testimony from the probation officer stating that it connected right to the internet. My client did give testimony today of confusion of the rules. He stated that on the January 20th, 2026, he was confused about the rules, that they weren't explained. That was his testimony. Mr. Carasso did complete the sex offender treatment. Unfortunately, there's more steps involved in order to get full access to the internet. Once again, my client stated he was confused again. The alleged admission of being tired of his flip phone, he wanted to pay bills online, that was some direct from his probation officer. Mr. Carasso disputes that, stating that he only had a phone, talks and text only was his phone that he had. So my argument, this is not a willful violation, Your Honor, and ultimately we're going to ask for a reinstatement.
Thank
you,
you.
Judge.
Thank you. Final word, Ms. Basso?
Ma'am, Mr. Carasso keeps saying that he was confused. However, he said he was confused in January originally. However, Ms. Perez did indicate that she had on more than one occasion actually instructed him and re-instructed him on the conditions. And the written conditions actually specifically do lay out the risk assessment needs to be done separately. So we believe that it was a willful violation.
Thank you.
There's, what about this stuff? Oh, man. Does not connect to the internet. You have to connect it to the internet, sir.
I'm going to turn off the microphone at your table, if that's okay, Mr. Koch. Sure. So I'm looking at the corrected order of sex offender probation. It was entered on February 19th, 2024. And it was nunc-pro-tunc to September 12th, 2023. It was entered by Judge Ketchel. It is docket entry 155 in the court file. And paragraph 30, it's on page 4, contains the prohibition on accessing the internet or other computer services until a qualified practitioner in the sex offender treatment program, after a risk assessment is completed, approves and implements a safety plan for the offenders accessing or using the internet or other computer services. I was reading that verbatim from paragraph 30. So that is the provision we're here on, correct?
That's correct, ma'am.
Okay. The court found Officer Varese' testimony to be credible, and the court did not particularly find the defendant's testimony to be credible. The burden of proof in a violation of probation case is a preponderance of the evidence. The court finds that the state has met its burden to establish that there was a willful violation of paragraph 30 of the corrected order of sex offender probation. And I am only considering the smartphone, the tablet. Officer Varese couldn't access it. There was no testimony that that device had been used to access the internet or if it was even capable of doing so. So this ruling is based upon the testimony regarding the smartphone. So the court does find that there has been a violation, willful and substantial violation of probation. So, sentencing today.
The state would be ready, ma'am, because it was a reverse split, so he does have a 20-year DOC sentence that we're asking the court to impose.
Defense, are you ready to proceed today?
Yes, Your Honor. Ultimately, we'll give some testimony from our client, but yes, we can move forward with that sentence.
Okay, and I'm looking at the same order I mentioned a minute ago, and it's in paragraph 19. And it states, a total of 240 months prison that's consecutive to 240 months of sex offender probation. It was a reverse split sentence. It was 60 months on count 1 and then 180 months on count 2 consecutive for a total of 240 months in prison. So the state is asking that that sentence be imposed. Is that correct? Okay. All right. So defense, would you like to present any testimony or evidence or argument?
Yes, Judge.
Okay.
I need some testimony from my client.
Let me turn on the microphone again at your table. Mr. Carasso, you're still under oath?
Yes, ma'am.
Okay. Well, let your attorney ask you questions, okay?
Oh, not read this?
Well, one second. Here. So, Mr. Carasso, the state is asking for 20 years to be imposed on the sentence. Now is your time to explain to the court. I know we have private discussions, but I know you want to get reinstated. Why is that important to you to get reinstated back on probation and not be sent to prison?
Because I won't survive prison at all because of my charges.
Is there any other reason? Why you want to get reinstated?
Yes, what about, can I say this one?
You can say anything to this court. Now's our opportunity. Yes.
Okay.
Explain to the court why you want to get reinstated and not go to prison.
Because I feel I didn't do anything illegally, but when she saw my cell phone and she says, that's not what I'm supposed to have, she said, I'll give you 3 days to get back to the regular flip phone. And I said, okay, and she said, if you do that within 3 days, I won't violate you. I did it within the first day. I called Joanne, and she came in, and we put it back to the flip phone, and that's when I found out the flip phone doesn't work on, to get the answer machine. So I did everything they told me to do, but what they tell me to do. I don't understand. I explained to her, I don't understand the paperwork on the probation paper because I'm not capable of comprehending it. Someone else has to explain to me each step, and that's what me and my ex was trying to tell her each time. And so as something comes up, I was hoping she would just tell me, okay, you do this now. Then I could say, okay, and I did it. And I followed all the instructions. There was nothing about taking an additional thing to get the internet. It just said that if I finished the classes, that I can get on the internet. And it also said I could be around kids, and it said that on the paperwork, and Varese says, no, it doesn't mean that you can be around kids. It says, well, where Joanne lives, there is no kids there, you know. And so all I was trying to do is get home so I can go do the probation part. But everyone keeps stopping me from going home. They say, you can't go home. Even though I have a 1,000-foot rule on my paperwork, they say where she lives is 2,000 feet. But I go, but I have a 1,000-foot rule. Can't I still go home? He says, no, Holmes County has 2,000 feet. And then later on, they told me now it has 2,500 feet.
I'm not sure what the geographic testimony has to do with what we're here on.
Yes,
So,
sir, we'll
okay.
move past that.
Okay.
So past the geographic living conditions.
Okay.
Is there anything else you want this court to know specifically? You want a reinstatement, now's
Yeah.
an opportunity. Why should this court give you another opportunity on probation if you have prior violations? Can you please explain to the court?
The prior violations I had to accept in order to get out the first time. Even though it wasn't on me, I had to accept the charges in order to get out. But the phone, when you turn it on, did not go directly on internet. It has to be accessed. The phone I had to be accessed to the internet. And I did not access it to the internet. The PO herself accessed the internet. Only thing I know how to do is only a few steps I know how to do on the phone. The rest I had to depend on my sister in California and my ex-wife to do anything else on the phone, because I'm sorry, I'm not technology understanding anything past a rotary phone. You know, you punch a button and you hope you did it right. I'm from a different generation. The only reason I have a phone is I have to have one because when I'm by myself, I fall, I got to call for help, and being by myself, even though I'm in a wheelchair, cannot do nothing myself. I need assistance on everything I do.
Mr. President, if you get reinstated, Clearly, there is an issue with internet cable devices. You can't even have a device that has internet access, period. So if this court allows you to get reinstated, which you want,
Yes.
will you abide by all the rules of probation?
Yes, as they tell me what to do. I can't, how do you say this? I can't understand what people say unless you simplify it. If you say something I don't understand, it takes about a minute and 30 seconds for me to process what you're saying, to do it. And then I have to repeat what they're saying. Is this what you mean? And they'll say yes or no. I've been that way all my life.
Thank you, Mr. Caruso. Your Honor, no further questions.
Thank you. Any argument, Mr. Koch?
Yes,
I didn't
Your
know.
Honor.
I didn't
I
know.
have no questions.
Okay, go ahead.
Yes, Your Honor, we're seeking a reinstatement. You heard from my client today. Clearly, there's an issue of internet cable device. Just from testimony from my client, he has some confusion on that. We're asking for a reinstatement, and my client understands that 0 internet cable devices, period. It's not that, even if you hit a button that connects to the internet, that's a violation. You can't have any internet cable device, period. I understand the rules properly. Clearly some confusion and some medical needs. So the defense is asking for reinstatement, Your Honor, with all the conditions for my client.
Thank you.
Respectfully.
Thank you. Ms. Boswell?
I'm scared.
And Mr. Caruso continues to exhibit what I would refer to as selective understanding. He always sounds like he's confused when he really is not. This case originally, ma'am, we're asking for the 20 years to be imposed because this is the agreement that Mr. Caruso made with the state. It was a significant downward departure for the molestation of a very young child. But because that child was fragile and really not able, her mental health was really going to be a question if we had to push forward, the family said, let's go ahead and give him the opportunity to see if he can make it in the community and not put her through that. So everybody agreed, okay, we'll give you the split sentence. You show us you can comply and not be a danger and do everything you're asked. What does Mr. Caruso do? He violates over and over again. He has violated his probation before. From the beginning, accommodations were made. Probation worked with Mr. Caruso to try to make sure that there was a stable environment. They tried to work with him to say, okay, you're going to be living in a hotel, we'll check on you. We'll make sure that we will make this probation work. He was instructed over and over again on the conditions. Ms. Perez herself indicated to the court that she instructed him at least on 2 occasions of all the conditions. So if he had any questions, he had adequate opportunity for them to be answered. Yet he continues to violate. He continues to come in and try to say, I'm confused, please don't send me away. Well, that's worked a few times, ma'am. However, it is now time to enforce the agreement that Mr. Caruso made. He said, I will behave myself for 20 years so I don't go to prison. I will follow all the rules. I will not be a danger. But he did not do so. So we're asking the court to impose the 20 years that he agreed to at the beginning of this.
All right. I'm aware that this is not the first violation of probation proceeding that we've had with Mr. Caruso, because I believe I was assigned to the case for the last violation of probation. Do we have a current score sheet? I see one from February of 2025.
Yes, ma'am, I do have
Okay.
one.
That was when Mr. Caruso's probation was reinstated previously.
Yes, ma'am, I can show it to Mr. Koch if you like, and I can provide it to the court if I may.
Yes.
This one does reflect all the violation points. It will be 207 total sentence points, 134 months minimum guidelines. But of course, we are asking the court to impose what was agreed to.
Thank you. Thank you.
What did I plead out?
These are your charges.
What are my charges?
Oops, let me turn off the microphone
Thank
there.
you, Judge.
And would you like the white noise on?
Please.
Okay, go ahead.
Thank you. Thank you, Judge.
Thank you, Mr. Koch. Yes. Thank you so much. So I've received the score sheet. It has 207 total sentence points. I saw Mr. Koch and Mr. Carasso having a conversation about the score sheet. Mr. Koch, are there any objections to the score sheet?
No objections for the defense, Your Honor, for the score sheet.
Thank you. So I'm looking at the original order. Again, it's corrected order of sex offender probation entered on February 19th, 2024, nunc pro tunc to September 12th, 2023, entered by Judge Ketchel. And in paragraph 19 on page 2 contains the sentence, the reverse split sentence, which the court finds appropriate to impose. So on count 1, the court will impose the agreed upon sentence, which is in this order, of 60 months, that's 60 months, prison with credit for time served, followed by, on count 2, 180 months prison for a total of 240 months of prison with credit for time served. Probation is revoked and terminated. The court will impose the following additional fees and costs. $150 cost of defense, that includes the application fee. but there's no attorney. I mean, the PD wasn't appointed at first appearance. So, I am sorry to interrupt, but I have a humongous docket
Yes,
today,
Judge.
so we got to move along.
Yes, Judge, on this, if I can just carry it over to his...
Yes. Do you want, now, there's an arraignment on the new case,
On his
but
arraignment, it's fine, Judge.
I mean, if you get appointed, and then if you file a written plea on the new case, then
Those will probably both move to a different
I
docket.
don't know if that would move the VOP, because it wouldn't have a future pretrial date set.
Can I set this for what would typically be the follow-on pretrial conference date, meaning this VOP? So in August possibly?
Yes. So we can set the VOP case, that's 22 CF 756. Ordinarily, I'd set it on July 21st, but I'll go ahead, since there's a new law, and set it on August the 12th.
Thank you, Judge.
Sure, that's the date that the pretrial conference is going to be.
This 26 case is set
for the out of custody date. You want me to move it to August?
Please, yes. And let me just announce that as well. The new case, 26 CF 1039, we're not here on that today, but Mr. Felder, you might want to listen to what I'm saying.
I'm
I'm talking
listening
about
to
your
you,
court
ma'am.
dates. Okay, thank you. So the 26 CF 1039 case is currently set for August the 10th for pretrial. It's set for July 16th for arraignment. I'm moving that August date in the new case to the 12th.
Yes, ma'am.
So as of today, both cases, felony cases, will be set on August 12th at the same time, but you're still going to have that arraignment date in July.
Okay.
So,
Miss Clark, can I have a word with you real quick? I want to go to trial. Like, I
sir,
ain't do this. so-
Sir, hold on a minute. Are you talking about your VOP case? That's what we're here on today.
Okay.
So that's 22 CF 756. We're not here on your brand-new felony case today. I just moved the court date so they'd be on the same day, that's all.
I appreciate it, Miss Clark.
Sure. So, right now, you don't have an attorney on your new case, the 26 CF 1039. Would you like me to appoint the Office of the Public Defender on that case?
Yes, ma'am, that'll be
Okay. All right.
Travis Gates.
Sorry. Okay. I am appointing, even though this case is not on our docket, I see that there's no attorney right now. I'm appointing the Office of the Public Defender in 26 CF 1039, which is Mr. Felder's brand-new felony case. So I suspect there's probably a motion to withdraw that's going to come since y'all had to withdraw off the 2022 case, but I'm just trying to put that process in motion.
Yes, Your Honor.
Okay. So, and this 26 case has arraignment on July 16th at 1:30, and then pretrial conference, we just moved the date. It's August 12th at 9. Okay?
Yes, Your Honor.
Thank you.
I'll get that moved into
Thank you, Judge.
What are you doing? What are you doing? You taking my case?
All right, thank you, Mr. Felder.
Thank you, Judge, that's all I have.
Thank you, Mr. Harper.
I'm still freaking out about where did it go? It's in the
Mr. Ballack, I saw Mr. Ballack. You were here. Are you ready?
I am printing off a plea agreement.
Okay.
as we speak, so I'm gonna write that down there.
All right, well, let me go ahead and take Mr. Shaw. I see Mr. Shaw.
I'll be happy to go, but I know Mr. Rare was signed up before me.
Okay, all right, well, Mr. Rare then, come on up.
Good morning, Your Honor.
Good morning.
For the record, David Rare, Judge. We're here on the state issued a request for a subpoena for medical records for my client Jennifer Borger. She's not officially on the docket, but we were given today's date for that. I believe the
Okay,
state
just-
has the burden to move forward to prove relevancy and nexus.
Just 1 second. So this case, it's not really a case yet because there's not a case filed. It's an
Correct.
investigative subpoena.
Correct.
All right, and so just to,
Generally with these, since they're not officially charged with the crime at this time, we ask that the cameras are turned off.
okay. So I am going to have to ask that the camera be turned off because this proceeding is not on an existing case.